the happenings in the Nungua traditional area. Now, let's hit the lines and speak to the Venerable Professor Raymond Atuguba, who is the Dean of the University of Ghana School of Law. Hello, Prof. Good morning. Welcome to The Big Issue.
Good morning, Chief.
Yes, happy to have you this morning. I trust that you've been following the matters in Nungua and what the whole discussion has been. Your initial thoughts on this before we delve into the subject proper.
My initial thought is that this is just one of several happenings across the country that seems to have come to the limelight. So we are not dealing with an isolated case. We are dealing with a systemic number of issues, and we need to approach the issue more holistically and not episodically.
Great. Will you say that the interest this particular matter has generated is positive, notwithstanding the various versions and the nuances we have seen play out in the last week? Of course, you said it's just one of the many practices or instances we may have across the country. You think that the interest this has generated, the fact that this has come to the public domain and the commentary on it is positive and must be encouraged?
It is positive. It is the hallmark of a democracy. One of the strengths of a democracy is that people are able to speak up about issues, discuss them thoroughly in the public space, and come out with solutions that work for the social good. So it is a positive development.
I see. That video or short report we played before speaking to you, we had one of the persons in there saying that this is their identity and nobody should interfere in practicing or when in reflecting what defines or identifies them. But we are a nation of laws. The law frowns against child marriage in this instance. Of course, they have said it is not a marriage to the Gborbu Wulomo and all of that. How do we address issues of cultural identity and the law?
So, Salam, there are two answers to your question. There's a formal answer and there's a less formal answer. The formal answer is pretty easy, straightforward, direct. The less formal answer is less so. So the formal answer to the question, what happens when there's a clash between culture and the formal laws of the land, is pretty simple. Our Constitution has answered that question. And our Constitution has answered it in Articles 1, 2, 11, 17, and 26. If you do a combined reading of Articles 1, 2, 11, 17, and 26 of the Constitution, the answer is right there for you. For example, Article 26 says that every person is entitled to enjoy, practice, profess, maintain, and promote any culture. That's what the provision says. Any person, every person, is entitled to practice any culture. But there are two conditions placed on that right. The first is that it is subjected to the provisions of the Constitution. So if you read the end of Article 26, Clause 1, it has the words, subject to the provisions of the Constitution. So the first condition is, make sure that whatever cultural practice you enjoy and profess and maintain and promote is subject to the provisions of the Constitution. There's a second condition, and that condition is contained in Article 26(2). It says that all customary practices which dehumanize or are injurious to the physical and mental well-being of a person are prohibited. So, Salam, basically, you can practice any culture of your choice, promote it, profess it, etc. But make sure that that culture or that aspect of the culture you are professing and practicing does not infringe the provisions of the Constitution, one, and does not dehumanize or is injurious to the physical and mental well-being of any person. Finally, on this point, I must add that if you look at Articles 1, 2, and 17, and especially 11, which provides the list of laws that are applicable to Ghana, it leads you to the conclusion that cultural practices and cultural norms and customary law are subject not just to the Constitution, but also to acts of Parliament, such as the Children's Act, to regulations made under various laws, and to some decisions of our courts and various courts. So, Salam, that's the formal answer. One is easy, okay? But the controversy doesn't arise out of the formal answer. The controversy arises out of the more informal implications of this answer I just gave you. And that leads me to what I have to say next. In a sense, the question you've asked me this morning on a clash of culture and law is perhaps premature. Because I believe that as a nation, we are intellectually incapable of posing that question. Why do I say that? We have not gathered the knowledge. We have not gathered the knowledge resources necessary to formulate a question on a clash between law and culture in the way in which you have formulated it and posed it to me. Let me give you an example. I learned a lot of culture from my late father. And after many years of these conversations, I came to the hard conclusion that I and many Ghanaians do not know our culture. We simply do not know it. I remember having this conversation with him about the bride price from where I come from in northern Ghana among the Grunshis or the Kasnanankanis. And our bride price is 2 cows and 8 sheep. And I asked him why the price was so high and whether it could not be construed as a transaction, a commercial transaction, where you'd exchange a human being for goods and for sheep and cows. Then he told me for the first time the real meaning of the bride price. He told me that nobody is ever expected to pay the entire bride price, and that anyone who attempted to pay the entire bride price was effectively insulting their in-laws. And that although he was a school teacher and capable of taking 2 cows and 8 sheep to my father-in-law, my mother's father, he sent 2 cows and 7 sheep because if he had added the 8th sheep, it would have been considered an insult. This is because the man is supposed to be perpetually indebted to his in-laws as a check on how he treats his new partner in that relationship. And that debt could be recalled at any time and was effectively used as a mechanism of the in-laws to discipline the man. And it was then that I remembered certain conversations that took place between my father and my mother's brother. That is my uncle. And anytime they were in argument and my mother's brother could not win, he would say, you need to give up. Otherwise, I would ask for the eighth sheep. It was at that point that everything fell into context. Giving this example because we absolutely do not know much of our culture. And second, we have over the years distorted our culture for various selfish reasons. And let me give you another example. I've already told you that the bride price is never to be paid in full for several reasons I've tried to articulate. Do you know what happens now? Because of greed, some people not only ask for the full bride price to be paid, they actually ask for an extra cow. And they have titled that cow the beauty cow. Because our daughter is beautiful, add another cow. Salam, can you compare the real purpose of the bride price to the current cultural practice? Do you see? This is why I'm saying that we are intellectually incapacitated from asking the question that you've asked me until we have gathered the knowledge resources to be able to pose that question properly. So, again, in the conversations I had with my father and also with other people, I have so many other fathers that I learned from. They brought to bear to me the vulnerabilities of our chiefs. In all the learning that I've done in culture, I have had to come to the conclusion that chiefs, at least in Ghana, are supposed to be very vulnerable. And so I cannot imagine how they became dictators in our modern day. Again, it's a complete abandonment of our culture. It was so easy to distill a chief traditionally. In some places, all he needed to do was to get his sandals off his feet. That's how simple it was to distill a chief. Try that today in Ghana Salon. Let me give you one last example about the role of women in our culture. Out of the learning I have done from several people, I am firm in my belief that in Ghanaian culture, women were never ever oppressed. It never happened. It's a complete lie. Women chose our chiefs. The eldest woman in the royal lineage was the constitutional court of the land, not the Supreme Court. She was higher than the Supreme Court. When the Supreme Court decided a matter, she could overrule the Supreme Court. Women, through the child born to the chief after he becomes chief, called the stool child, were the only people allowed to disrupt judicial proceedings when the chief and the elders were sitting. Women could compel a chief to abdicate. Women were the traditional executioners of family heads and chiefs. If you misbehave, they would finish you in order to protect the broader society. Women were a critical part of our military formation. Go and ask about the military formation of the Dagomba and the Konkombes and the Ashanti. And tell me the role of women in that military formation. And then come back and tell me that this is a group that is capable of being culturally oppressed. It is a complete farce. We need to re-examine our culture, find out what it really was, and make it work for us. And Salam, I've done some work on this. I'll send you an article I wrote. It is titled The 7 Phases of Cultural Law, of Customary Law in Africa. It's possible that it's even on the internet. In that article, I have traced the evolution of customary law from the very beginning. And I came to the conclusion that there are 7 different types of cultural, the customary law in Ghana and in Africa across time. And that if you say customary law today, what you're saying is literally meaningless unless you point to us what specific aspect of customary law or what type of customary law you're talking about. We have precedent customary law, we have judicial customary law, we have legislative customary law. So again, it goes to the point I am making that we are a culturally confused lot. Our culture is jaundiced, adulterated, for both good and for bad. We need to start focusing on the adulteration and changes of our culture for good and not for bad.
I see quite interesting points you've raised there, and quite a number of things you take from the culture. Yes, so there could be good culture and bad culture. But bad culture by whose definition? By the definition of the law. And law evolves over a period. So at what point do we say that a particular cultural practice of the people becomes injurious or becomes frowned upon by the law which has been predated by that particular cultural practice?
Yes. Thanks, Salam. The question you've posed is simple but complex. It's simple because I could tell you straightforward that when the Constitution, when an act of parliament, when a regulation, when a judgment of a court decides that a particular culture is good or is bad, then it has to be treated that way. Because these are the institutions for lawmaking that we have established. But the deeper part of your question, as I've said, is whether or not we know enough about those cultural practices in order to pass a value judgment. Salam, do you see where I'm going?
Mm-hmm.
My mother told me about FGM because she underwent FGM. And when she told me about FGM, it was about an entire cultural process that involved, of course, excision, but also involved education, counseling, community relations, so much more than the curtain. Salam, are you following?
Mm-hmm.
Where a society picks out one element of that culture, the curtain, and makes FGM all about cutting, and then demonize it and illegalize it, there's a problem.
Oh.
And that is why the Gambian parliament has just passed a law to reinstate FGM.
Oh.
Because what they are saying, what the Gambian people are saying is that FGM is more than cutting, and that you can have the practice of FGM without the cutting. Salam, are you following?
Even though the name is female genital mutilation, you do the FGM without mutilating the genital.
And the name is FGM because those who tried to demonize it gave it that name. Traditionally, it was not called FGM. They were named as rites of passage and phases in the education of young girls. So what they are trying to say is that we have a culture for the education of our young. And we have come to realize that that culture is important and that banning it is not good for our society. So, Salam, the point I'm saying, no one should go and quote me that
Prof says FGM is good and should be brought back.
I never said that. I said that FGM is a wrong characterization of a cultural practice that meant far more than that. And that, from the narration my mom gave me, who herself underwent FGM, went far and beyond the curtain.
I see. So it does appear. So, like the FGM example, for example, it was meant for something else, but those who you say wanted to demonize it, gave it a name, And so that characterization, in the end, resulted in it being outlawed. You know, are we not at risk of losing our identity, losing our cultural practices, things that define us or things that identify us, to the modernism of the law? So that the same way the real intent of FGM, like you just explained, is now being maybe, I mean, it's been outlawed. I mean, it's been confused and outlawed subsequently. Are we not at risk as a people of losing our cultural identity to processes like what led to the FGM, for example, being outlawed?
Yes, Salam, you are exactly right. Okay. And what I'm saying is going to tread on the line somewhere. And I just wish that people listen to what I'm saying rather than listen to what they think I'm saying. I personally believe that the way out of our current developmental mess is a cultural one. Let me repeat that. I personally believe that the way out of Ghana's current developmental mess is a cultural one. Part of the economic and political and social miracles of development that have happened around the world have been cultural. So, for those who doubt what I'm saying, I am going to provide evidence of this from our Constitution and from our Courts Act. Let's start from our Courts Act. The Courts Act is on the internet, you can read it. And I want you to read specifically Section 54 of the Courts Act. When the good women and men who drafted this Courts Act sat to draft it, they recognized that there are a lot of our society was still culturally functional. And so they provided in that section that when disputes go to court and you want to settle them, the first thing you should do is try to settle them according to the personal law of the parties involved. Salam, can you guess what the personal law of most of us is? It's customary law. So in as late as 1993, when this Courts Act was being drafted, the people who drafted it knew that part of the way of resolving disputes quickly, efficiently, without backlogs of hundreds of thousands of cases was a cultural one. And if you use culture, the personal laws of the people, you will resolve these cases very fast. Salam, I was ever someone before, when I was a kid, before the Damongura's house, that's the chief of the Gunjas, because the pigs my dad asked us to take care of went away and destroyed the farm of the sister of the Yabungra. And so we were summoned before that court. We went with our lawyer, who is my dad, because in the traditional court, if you go to the traditional court without a lawyer, they would think you are crazy. So they'll send you back to go and bring a lawyer, if they know what they are about and if they know what the culture is. And that case, Salam, a complicated case as this, the Yagungra is higher than the Damongura. The Yagungra is the overlord. He's like the Asantino of the Gunjas. His sister's farm was this. Can you estimate the amount of trouble we're in? Salam, by using personal laws, that case was resolved in 1 minute to the satisfaction of all the parties. In fact, the Yagungra sister left that court after 1 minute smiling broadly, even though her crops were destroyed. So our legal technicians and parliamentarians and the rest know what is good for us culturally. But Salam, do you know what has happened to that provision? It is never implemented. Let me give you a second example, second and last example.
Before that, why do you think it's never implemented? Where is the gap? Why so? What's the difficulty?
Good. I'll come to that question right after the second example.
Okay.
Is that okay with you?
Yeah, it's fine.
Because it will be clearer. So I now have two questions to answer. The first is the second example, and the second is why is it so? Our constitution, again, the constitution is on the internet. Okay? And we keep reading those parts of the constitutions that are selfishly important to us. But we ignore those parts of the constitution that are for the common good. So those who haven't read Article 39 of our Constitution should read it today. That provision says, and it is titled Cultural Objectives. Let me find it and read the exact words to you, so that it's not Raymond saying it, it's the Constitution saying it. Article 39. It says, quote, the state, Salam, are you with me?
Yeah, so 39.3 you are reading.
The state shall take steps to encourage the integration of appropriate cultural values into the fabric of national life through formal and informal education, and the conscious introduction of cultural dimensions to relevant aspects of national planning. Salam, I'll take that again. The state shall, it's not may, Salam, it says what? Shall. The state shall take steps to encourage the integration of appropriate customary values into the fabric of national life through formal and informal education, and the conscious introduction of cultural dimensions to relevant aspects of national planning. So again, just like we ignored Section 54 of the Courts Act, Salam, we've ignored Article 39 of the Constitution. This time not the Courts Act, but what? The Constitution. When I am teaching law to our students and I try to apply this provision and introduce cultural dimensions to what I'm teaching, they get confused, they start wondering what I'm doing, and it takes me hours to explain for them to get it. So again, we are not doing it. Now the question you've asked is, why are we not doing it? Right? Many reasons why we're not doing it. We couldn't finish it in this interview, but let me just list some for you that come straight to my mind. The first is that as a nation, we do not appreciate the cost of a persisting colonial, political, economic, social, legal structure. In other words, the colonial, political, economic, social, legal structure has not left us. It has just mutated. And as a state, we have not yet understood the cost of that persistence. And because we don't understand the dimensions of that cost and the fact that it is keeping us perpetually down, we have decided not to change it. The second reason is that there are a lot of people benefiting from that system. There is a 10%, maximum 25% of our population that benefits from that colonial structure. And so they would not want it to be changed because they feel that they would lose out. Okay. Meanwhile, the 75 to 80% of the population who are bearing the cost of this colonial structure do not have the appropriate levers and capacities and resources to change that system. Now, this results in leadership inertia, the persistence of conservatism, and sometimes just pure laziness. We are so lazy in our approach that we just follow what is there. We need to pass a nuclear act. We pick the nuclear act from the UK, copy it. Wherever we see Ghana, wherever we see UK, we put in Ghana, dust it, and take it through Parliament. The parliamentarians will read it and they'll pass it. Civil society could have helped, but they seem to be quite teleguided. I have run civil society organizations before, and I know what I'm telling you. You are urged and almost compelled to go where the money is, so you can make the end of month wage bill, and you be constrained to bring in activities that are more for the national good than for where you are being teleguided. So, Salam, these are some of the reasons.
I see, quite interesting. My guest is, this is a big issue, 97.3 Citi FM. My guest is Professor Raymond Atuguba on this part of the show. We're looking at the general issue of law, culture, and ethics and all of that, how they can coexist. And he makes a seminal point that the way out of our current developmental mess is a cultural one, and he buttresses that with Article 39 of the Constitution and Section 54 of the Courts Act. We're looking at this against the backdrop of the incidents or the happenings in Nungua, where the Gborbu Wulomo, age 63, was reported to have married a girl 12 years old, as was initially reported. Of course, matters have evolved or changed since then. We understand the girl is 16 and that he was not marrying the girl or the lady. The lady was actually getting married to the deity. So that's where we are now. And a number of institutions, civil society organizations, the state, etc., have issued statements and spoken condemning the said marriage and all of that. That is the context of our discussion today. So, Prof, I mean, we get in wrapping up. I mean, the girl issue or the case study, the matter we are looking at and drawing lessons from. There's what we call the welfare principle in the Children's Act, for example. Many have said, indeed, the proponents of this particular act have said that it's in the interest of the child for her to go through this process. It's a privileged position. And indeed, they've said that many of her colleagues and peers would wish to be in that situation, the parents and a lot of people. Apart from the age question, which is key, what will you say becomes a position of the welfare principle, for example? Is it okay to leave a 16-year-old or a young lady to go through all of this in the name of culture? Or you think that there are other considerations we have to make?
Well, Salam, I've essentially answered that question for you by proposing two answers. I've told you that under our Constitution and under our Children's Act, no one below the age of 18 can legally get married. Out of the question. That is the law in Ghana today. Okay. I've also said that under the Constitution, Article 26, any cultural practices that is dehumanizing or that is injurious to the physical or mental well-being of any person is outlawed. Okay. The problem, Salam, is that we do not know enough about our cultural practices in order to pass a value judgment. Do you see the point I'm making? And I've given you personal experiences of instances where I thought I knew the culture and I was rudely shocked at what the real culture is. And don't be deceived by those who do not understand the culture or have joined the culture for their own selfish desires. That's not culture. That's not culture. That's a personal crusade. If I pick an aspect of culture and I mutilate it to satisfy my personal desires, that's not culture. In fact, that's criminal.
I see. I mean, it throws the discussion quite wide and takes it from the realm we were looking at it from. I mean, of course, it's quite a nuanced conversation. So in all that we have said so far, the law, what the law is, what the culture is, and all of that, what is your proposal of resolving this particular case in point? How will you suggest that this matter be resolved? Is it a criminal route? What you've asked, I mean, is it investigations to proceed? I mean, how do you suggest that we resolve this as a people?
As a state, as a people, as a proud people, if you hear that a 16-year-old child is betrothed or married or whatever it is, your first step is to take it seriously and investigate it. Very first step. You cannot allow such, even if it's an allegation, you cannot allow it to pass. You have to take steps. First, to investigate it, and then take appropriate action. Salam, all I'm saying is that whatever investigation that is going on must include an investigation into the authentic cultural practice that is at play here. Because I can bet the shoes on my feet that a lot of us, including those who purport to be articulating the culture, may not really know what that authentic culture is and its purposes.
I see. Can you clarify this for us as well? I mean, now we understand that the event or the ceremony was towards marriage to the deity and not the person. What does the law say? Can a human being be married to a deity or a spirit or a god?
The law does not recognize the humanness of deities. So you can't go to the marriage registry and say, I am getting married to a deity. At the same time, the marriage laws recognize customary law. Now, I don't know if under customary law, marriages to deities are permitted. In fact, I don't know what it means in custom when you say that somebody is married to a deity. Salam, are you following?
Mm-hmm.
But you and I don't know what religion you practice.
I'm a Christian.
Good. We Christians know that such marriages exist. Any practicing serious Christian who prays knows that there are instances of marriages between human beings and things that are not human beings. Salam, let me stop here.
No, I wish you would continue. Of course, we hear, of course, we call them spiritual marriages and all of that. But that cannot be tested.
No, I've not only heard, I have seen.
Oh, you've seen spiritual marriages, I mean, between human beings and spirits. But that cannot be tested in the eyes of the law. So that leaves a bit of a difficulty in accepting that this could be marriage recognized by law. But by law, by which law? By customary law, which is accepted, or do we test that customary law against the bigger law, the basic law, the constitution, and maybe the acts of parliament, the Marriages Act, for example, which clearly defines what marriage is? That is a bit of confusion I wanted to clarify for me.
So, Salam, there's something called the limits of the law. In other words, every sophisticated society knows that law has limits. Okay. What you are posing to me now may be an example of the limits of the law. What a society does when it arrives at the limits of its law is to start processes for ensuring that societal knowledge and societal progression is not attenuated by the limits of the law, and that you explore mechanisms for either expanding or contracting or stretching the law in appropriate forms so that the law does not break. This scenario is an example of a point where the law is about to break, where we are confronting the limits of the law. And that's why I'm happy that many people in our society, many leaders in our society are focusing on it, because it is the only way that we can recognize the limits of the law and allow the law to reform to cover it. And when I see members of the executive, ministers of state, parliamentarians all chipping in, I am happy, because it is through those discussions and deliberations that we would arrive at a point where a proper decision can be made on this matter.
Prof, we want to thank you so much. I mean, it's always refreshing hearing you speak on such matters, and indeed on all matters, and enjoying your classes and everything. It's a great pleasure having you this morning to throw some more light on this very controversial matter, and indeed looking at it broadly from the context of law and cultural practices. We are so grateful for your time this morning. So Professor Raymond Atuguba, Dean of the University of Ghana School of Law, has been my guest for the first part of the program. Thanks so much to him for making the time to take us through all of that. Very interesting things he has said this morning. We'll take a short break. When we return, we'll delve into the discussion proper, and my guest will be right up here, Executive Director, Child's Rights International, Dr. Hilda Boyd, President, Pediatric Society of Ghana, and Reginald Niwi Ayibonte, former Member of Parliament for Odududu constituency, and he's a traditional person as well. Don't go away. This is The Big Issue.